Well, here we are again, lesson 14. Now, this is the second half, then, of the motion section of the course. I've set 6 hours apart now for motions, briefs, and affidavits, so that we would cover, in 6 hours, the most important segment of any trial or of any case, judicial case, that there is, and that's the motions and briefs, because they represent 50% of your case. Everything that you put in is going to be done in writing. Fortunately, we have a computer that does most of the writing. As I said in the last lesson, this entire case is a winning case. When you follow this case through from beginning to end, you'll read the transcript of a preliminary hearing in here. This case never went to trial. It was dismissed by the prosecutor about 4 or 5 months after the charges were initially brought. The prosecutors like to play sudden death. They will bring charges against you about 3 times in excess, let's say 3 times in excess of what you've really done or allegedly have done. For instance, if you are driving down the road and you've got a tail light out and a policeman stops you and you give him some lip, he'll charge you with obstructing and delaying, drunk driving, no driver's license in possession, speeding. In other words, he'll lie a little and he'll add some more to the charges. This is a very common practice. That's not to say that every policeman does that, but it's very common for those policemen who don't like constitutionalists. That's a dirty word. It used to be if you were a communist, that was something bad. Today, if you're a constitutionalist, that's worse than being a communist. Then they'll trump these charges up. The purpose for that is plea negotiation. It's the same thing when you're talking about missiles. On our side, we want to have a lot of extra missiles over here so that we'll have bargaining chips. And this is what the prosecutors do. They use these charges as bargaining chips. My guesstimate would be that if a citizen were to plead not guilty and argue his case, if it's prepared correctly, to the Supreme Court, 90% of those cases would be won. 10% would be lost even though you're innocent. The way it comes down now, 90% are lost, 10% are won, because the defendant is innocent. Prosecutors have a habit of trying to prosecute more and more cases because now there's no grand jury to stand in their way. Without the people, without the grand jury. Now, government agents decide what is crime, what isn't crime, who will be prosecuted, and who will not be prosecuted. And in this way, they can separate those of us who are political threats to the stability of the power structure, and they can charge us with income tax evasion, willful failure to file, and numerous other misdemeanors and felonies. One of the basic reasons that they like to charge people like me with felonies is that will then preclude me from public office or public service. The truth of the matter is they could save their time, effort, and energy because I wouldn't take public office if it were given to me. Nevertheless, I'm going to live like a free man, and I'm not going to serve these tyrants. I won't give them so much as a quarter. I'll spend the rest of my life in a penitentiary before I will bow down and serve Moloch and Baal, or before I'll surrender to Anakims. Now, I know that there's a little humor in this entire process. If there wasn't, we'd all go insane. The humor comes in the courtroom, because you see, the courtroom is the place where you're going to gain redress of grievance. I think I've mentioned in the past that I've attempted to seek redress of grievance along with the John Birch Society by writing letters and postcards to my senators. Nothing of great substance has changed in the last 20 years to my knowledge by writing letters, so therefore it's my observation that I've failed twice. 1, I figured out I'm not a prophet, and 2, I figured out I can't change the course of events or secure my freedom by writing letters. So I took up a new challenge, and I went into the courtroom, and I found that not only can I accomplish something for myself, I can accomplish a whole lot for my fellow man, and at the same time I can secure my own freedom and have a lot of fun in the process. If it wasn't fun, I wouldn't do it. I think I've said before, and I'll tell you again, I used to employ 30 people, produce $1 million a year, and pay about $200,000 in taxes. Today I employ no one, I produce nothing, I pay no taxes, I teach thousands of other people coast to coast how to do the same thing, and I have a lot of fun in the process, and I'm sure that a lot of other people are having fun too. Whenever I talk to somebody on the telephone, which is about 4 or 5 times a day, someone calls me from Maine or New Hampshire or Georgia or Tennessee or Texas or California, and they want to know, well, am I doing this right or whatever? And I always try to tell them, when you get into that courtroom, boy, you better be having fun, because if you're not having fun in there, it's because you're not handling it correctly. I had a great deal of fun when I did this particular case, and I think I've had fun on just about every case that I've taken up. And I said in the last lesson that one of the first things you're going to do is you're going to take a lot of paper and you're going to file it just like this. You're going to just stick it in because you're busy. And when you do that, you're not going to read it. And then when you get onto the courtroom floor in a motion hearing or a suppression hearing or something on that order, I can just picture this. You're going to motion up a suppression hearing, and when you get in there, the judge is going to say, well, now, what was it, Mr. Jones, that you wanted to suppress? And you'll go, well, I want to suppress evidence. Okay, well, what evidence is it that you want to suppress, Mr. Jones? Well, I'm not really sure I know what evidence. See, I haven't gotten the evidence that the prosecutor has. Have you motioned it up under Rule 16? No. What rule is that, Judge? I don't think I know and understand that. I say, well, then you're going to have to motion it up under Rule 16, and then you're going to have to tell me what evidence you want to suppress. Otherwise, I can't suppress it. Does that make sense? When you get into a bind like that, and this just happened the other day, a young fellow went in and he motioned up a suppression hearing, and he didn't even know what the word suppression of evidence meant. And I'd said before that probably the most valuable book or the most valuable publication is this thing called the Search and Seizure Law Report. By now you should have read 100 cases out of Search and Seizure Law Report up to Lesson 14. If you haven't read 100 cases of Search and Seizure Law Report, let me take a moment here and tell you a little about it. It's a Reader's Digest synopsis of the Fourth Amendment. And it covers literally hundreds of different persons in different circumstances that range from bank robbers and drug addicts and drug pushers and tax rebels and tax protesters and, you name it. And there's examples in there. The Fourth Amendment is ruled upon more often than any other section of the Constitution. And in there you'll find what evidence and in the manner in which the evidence was gathered from these various individuals. Let me give you an example. There's a fellow named Schmerber, and it's called Schmerber versus California. And he got in an auto accident, and he was unconscious along the side of the road. And the policeman ordered a medic there to take a blood sample out of his arm. They did. They took the blood sample, and they found that he had been drinking, and they prosecuted him. And I think he filed his motion to the Supreme Court, or his appeal to the Supreme Court, and they upheld the conviction. And the question was, well, can you take blood out of an unconscious man's arm and then use it against him? I think he'd probably move for suppression of the evidence, and the trial court had left it in, and the Supreme Court said, yeah, you can do that. In another case, a fellow took some heroin, and he swallowed the heroin, and they took him to the hospital, and they operated on him and cut him open, and they took the heroin out, and they used it against him. And the Supreme Court said that so shocked the conscience that they would throw that out. Now, what's the difference between a man swallowing heroin and a guy who has his blood taken out of his arm? Well, the difference is in the way the Supreme Court looks at evidence and the rules that they make pursuant to evidence under the Fourth Amendment. Now, I don't know if it's right or wrong or good or bad, and I'm not here to tell you that the Supreme Court did righteously in the Schmerber case and they did wickedly in the other case or vice versa. I don't know. I'm just telling you that that's the way it is. Now, I'll tell you what that does for me. You see, if I had a little packet of heroin, what I would do is I'd plop it in my mouth and swallow it, and then I know that they can't use it against me because it's gone and they can't operate on me, and if they do and they take it out, I can get it suppressed. On the other hand, when I'm involved in an auto accident and I'm dead drunk, I know not to get knocked out because if I'm unconscious, they can take the blood out of my arm. So therefore, if I'm conscious, I'll put up my Fourth Amendment barrier. I'll pull down the exclusionary rule. So therefore, the moral of the story is, whenever you're drunk involved in an auto accident, do not lose consciousness, or else they'll take the blood out of your arm and they'll use it against you, and they'll do so successfully. Now, there's literally hundreds of other applications of this thing called search and seizure, and the use of the exclusionary rule and the use of a suppression hearing. Let me just take a look quickly here, that's while we're on this subject, and take a look at the suppression of evidence here under, see if I can find a motion in here. I thought I could. Now, if you'll take a look in Black's Fifth, looking down here into the subject matter of motions, you'll see that there are a number of different types of motions. Okay, one of the motions that you're going to find here is a motion to suppress. Okay, so a motion to suppress is a letter to the court that you want to notice up a hearing and a motion to suppress. It is a device used to eliminate from the trial of a criminal case evidence which has been secured illegally. Okay, so here's Schmerber. He contended that the blood taken out of his veins was taken illegally. The Supreme Court said, nope, it isn't. All right, end of the argument. Generally in violation of the Fourth Amendment, that's your search and seizure rights, or the Fifth Amendment, which is your privilege against self-incrimination. So let's take a look then at the Miranda rule. They arrest you, they take you to jail, they tell you to sign this evidence form or this confession, and they keep you there for 5 days, they beat you unconscious, and they force you to sign it. Can they then use that against you? So you'd go into a suppression hearing and you would then present your evidence. And you'd say, this evidence, this signed confession, did you notice the blood on it, Judge? Did you notice that I wrote CF after my name? Did you notice that I signed it under threat, duress, and coercion? Did you notice, Judge, that when I came forward the very first time at the bail setting hearing, I said, I've signed admissions and confessions in here that were beat out of me against my will and over my objection. Have they secured my name on numerous documents in here? You see, if you set the record early on, right at that bail setting hearing, Your Honor, I've been beaten up in here. I've signed admissions and confessions. I've signed all kinds of things. I don't even know what I'm signing in here. And let the record show I've never had counsel and I've been in here for 3 days. Well, under the Miranda doctrine, by the time that issue gets to the Supreme Court, you've got that one won hands down. There isn't even anything to argue about. If you think there is, take a look at Miranda again. And by now, by the way, you should have read the Miranda doctrine from beginning to end at least once. And you know, I read that Miranda case 2 or 3 times a year. That Miranda case is so valuable to a patriot. And what we're doing here and going into the courtroom, that's one that you really need to know and understand and be able to cite certain sections like the testatrix formula on page 458 or the rights doctrine on page 491, things like that. All right, now, the Sixth Amendment is also included in this suppression hearing. That's your right to the assistance of counsel and a right of confrontation. Now, if you'll notice that when you're in jail, remember the jailhouse scene, you're always demanding counsel, aren't you? And if you're not demanding counsel, I would say that on a scale of 1 to 10, the most valuable single constitutional issue you can raise is the counsel issue. I believe it's number 1. And if you're charged with a felony, I think that the grand jury, the information, is number 2 and 3. And I would go on to say that probably the Fourth Amendment and the illegal gathering of evidence would be about number 5. And we were just going over what was this called, a writ of prohibition that we're planning to file in the United States Supreme Court. And Neelis and Bob and I were going over it. Neelis wrote out 14 constitutional rights that are routinely violated here in the state of Idaho. I mean, routinely violated. You can go into any jail, you can go into any courtroom, you can be arrested by any policeman of these 14 violations, including counsel and grand jury, prosecuting attorney, the 8 jurisdictional defects, and I could go on and on, are routinely violated. That means that in Idaho, I don't think that the police personnel are competent to get a conviction that will stand up, not a lawful conviction, pursuant to the standards set down by the Supreme Court of the United States. And I don't think that if the issue was brought up correctly, even the state Supreme Court in Idaho would uphold 90% of the convictions based upon the rights violations that transpire. Now, the way they get around those rights violations is that the court will just practically enforce upon you that public defender. And what that does is practically wipe out all of your constitutional rights. Almost all of your rights issues will be covered by that public defender. He's really a trained mercenary. He might as well work for the prosecutor's office. He's there to cunningly coerce you out of your rights. He will go in and waive your rights to a preliminary hearing. And if he does demand a preliminary hearing, he'll go in and ask 10 innocuous questions and you'll be bound over. I've never seen a public defender yet put up a defense. They simply go in and apply the rules to make sure that the rules send you to jail lawfully and legally. In every case that I've seen where a public defender is involved, their caseload is either so high or they're so young and they're so inexperienced when they come out of law school and go to work here in Ada County, as an example, that they don't put any effort whatsoever into a trial. And I don't think there's ever a victory from the public defender's office, so you might want to keep that in mind if you think if you're so timid and you're so afraid to face those anakims by yourself. You just remember that having an anakim as your armor bearer, I don't think is going to help you very much. Now, this motion to suppress I didn't use in this particular case. Remember, I brought up a subpoena ducis tecum, and I said, I want you to bring forward the evidence that you're going to use against me. I want that evidence right here in the courtroom. They didn't produce it. That was an appealable issue because that was a meaningful hearing. I was denied counsel at that meaningful hearing. When I went to the preliminary hearing, when it was over, I had 2 reversible errors. Remember? When I went to the preliminary hearing, I brought to the attention of the court that I needed counsel of my choice, which is one of the issues I'm going to explain to you here in this lesson along with the rest of these motions. The right to counsel, this is number 203 on page 60, so you need to use this legal quotations book. And there's a number of legal quotations in here that you should just know. You don't need to memorize them, but you need to know right where they are. When you're talking about counsel, they start here on page 60. The right to counsel at a criminal trial is deemed so fundamental to the interests of justice that denial thereof automatically vitiates any conviction obtained. And that's called the automatic reversal rule. This is true even though there's no showing of any prejudice or unfairness in the proceedings, or even of any need of having counsel. When I finished the preliminary hearing, I had won this case, right there. And I think I went to the preliminary hearing probably in May or June, and it was dismissed in August. So the prosecutor will leave you right on that hot seat. And he'll take you oftentimes right up to trial, and a lot of times they'll take you through trial. And I think even they know that they don't have a hope of making that conviction stand up. And in Ada County, the prosecutors are only prepared to take you through to the jury trial. They are not prepared to go forward from that point on and argue all of these motions and briefs. And every one of these issues in here is a potential winning issue, just like Almeida Sanchez. Any one of these issues that I've brought up could be the issue that would reverse the conviction when taken to the Supreme Court of the United States. And all of this, remember, is put in prior to trial. So when you get into the courtroom, if you get into trouble, which you are probably going to do, and the judge brings up something in the motion or brief, Your Honor, I'm not sure that I understand that position. I'd like to take a week to study this particular motion, and if I've made an error and I haven't presented the proper motion in the proper format, I'll withdraw the motion from the court. Let's go over that one and take up the next issue, which is rights. Let's go take up the next issue, which is, in other words, apologize to the court and tell them, give me a week and I'll withdraw the motion. Okay, that'll give you time enough to study it, and then when you go back a week later, you should be able to argue it. You know, really the fundamentals of this is this. You should know and understand what your rights are. As an example, if you're an airline pilot, and, well, let's start out like this. I remember I learned how to fly many years ago, and the first airplane I learned to fly in was an Aeronca Champ, and it probably had about 6 or 8 instruments in it, maybe max, I don't know, but it didn't have very many. And we learned to fly that one, and then I think I moved up to a, I don't know, maybe a Cherokee or something like that, and gosh, it just had instruments all the way across the instrument panel. And it just had a lot of them in it. I think it was a Tri-Pacer. I'll take that back. It was one of the old 57 Tri-Pacers. And then I noticed when you got into retractable gears, gosh, there just seemed to be buttons and gadgets and switches and things, and down here on the floor there were fuel switches and one thing and another, and gosh, there was horns and bells and buttons going off all the time. And then I noticed when you got two motors on the thing that the instrument panel just got twice as big. You know, you had to have fuel gauges for both engines, and you had to have suction gauges for both engines, and gosh, it just multiplies. And by the time you get up to a 747, it probably takes 3 guys in there just to read all the instruments in there. All right, now here's the moral of the story. You're better off to stay in that Aranca Champ and understand all the instruments in there so that you can fly the airplane than you are to prematurely get up into the 747 and then get bogged down and confused with all of the, instruments in here. And that's where you're at when you're talking about law. You're better off to stay out of the federal district court, stay off of things like felonies and heavy charges until you've gone through the traffic court 3 or 4 times. Now, I've done 33 criminal cases and 4 civil cases to this moment in time in the last 5 years. If you want to get serious about this, you'll probably want to do 2 or 3 cases a year. If you're not serious, you'll just do the 1 traffic ticket that you get every year, and then you'll just be a part-time pro se. You call yourself a pro se, but you actually appear defensively in propria persona. And when you're doing it offensively, you appear pro se in a civil action. That's the proper way to plead your causes and your actions. Okay, now, on the suppression hearing, when you go in to suppress evidence, there's going to be 3 categories of evidence that you want to suppress. Okay, and the evidence that's going to be suppressed will be things like, let's take the 4th Amendment. That is, all evidence that's been seized in violation of your 4th Amendment rights to a search warrant, that is, search and seizure. That is, did they search the trunk of your car or under the seats or something like that. Okay, then the next one is the 5th Amendment, and you want to suppress everything that you've signed in the jail, any paper, any documents, anything like that that they might have secured. You want to move for the suppression of it. And then the 6th Amendment comes into play. You've been denied counsel, and when you've been denied counsel, you want to eliminate all evidence because it was seized and it's being used against you without counsel. So therefore, what that really theoretically boils down to, you've got this dumb man over here who doesn't understand what's happening to him at all. That's you, or me. Let's say I'm me in this case. And they've denied me counsel. Move for suppression of everything that they've got, period, because you don't have counsel. Now, you see, if you had counsel, that counsel theoretically then would be able to tell you, well, that's admissible evidence and that isn't. This is admissible and that isn't. And you would separate out the admissible evidence from the unadmissible evidence, and then you would only move for suppression of that which is suppressible evidence. As an example, Bob Hallstrom had a gun on him one time, and he was in the courthouse, and this policeman jumped on him and took his gun away from him and arrested him. And when they were arguing the case, Bob walked in and he said, "I want my gun back." And they claimed that they needed it for evidence. And he said, "You don't need it for evidence. I'll stipulate to the fact that I had the gun on me and that it was concealed. The issue isn't whether or not I was carrying a concealed weapon. The issue is whether or not you can prohibit me from carrying a concealed weapon." So he wasn't attempting to suppress the gun itself. So it was superfluous. It wasn't necessary to do that. Okay, now, another case, though, where you might have a suppression of evidence hearing, let's take a traffic case, and in your car there's an open bottle of whiskey that's under the seat, and you demand a warrant, probable cause, and a lawyer or counsel present. The policeman arrests you. You get out of the car, and now his probable cause was that you were speeding, and so if he pulls that whiskey out from underneath your car and tries to use that against you, that's suppressible. You suppress that. He didn't stop you because you were drunk. He didn't stop you because you were drinking or because you had an open container. He stopped you because you were speeding and you were defending your rights. You were demanding your rights. And remember that the Supreme Court finds it intolerable that one right should have to be waived in order to assert another one. And that was number 4 over here. I like to keep reminding myself of these. Yes, number 4. We find it intolerable that one constitutional right should have to be surrendered in order to assert another one. Okay, and then number 24. I chain reference these in here, by the way. I'll get one like that, and then there's a second one, and I'll grab it and see if I can find number 24. And this is exactly where you're at. The claim and exercise of a constitutional right cannot be converted into a crime. All right? I was in the jail not long ago, and here's an example of how they convert a demand for a constitutional right into a crime, and you need to address this by motion. Now watch how this comes down. I'm in the jail and they want to take my fingerprints. Would you get a court order, sir? I don't want to waive my Fifth Amendment right and give you my fingerprints only to be used against me in some other charge. Remember, if you give him your fingerprints and they find out by putting it in the computer that you jumped ship over in Seattle in 1974, well, now they've got you from desertion from the Navy, in addition to the speeding ticket. Okay, they didn't arrest you or stop you because you looked like you were a Navy deserter. They stopped you because you looked like you were a speeder. And then you asserted and demanded your rights, and so here you get into the jail, they want your fingerprints. And you know that in the last year or two that we've been using this here, I haven't had a judge yet issue a court order. Now, there's a simple way to do it. It's called Davis versus Mississippi. If there's probable cause, there's no reason why that judge shouldn't issue the warrant. But when he issues the warrant and you give them the prints, they better have probable cause under the Fourth Amendment or they won't be able to use the evidence against you. What probable cause do they have to believe that you're wanted for some other crime, some other event? All right? So that then would be the suppressible evidence. If they issued a court order and there was no probable cause, the judge, and this could happen a lot of times. You know, there's a lot of lower court judges out there that issue warrants, and they don't really understand the Fourth Amendment either. And that's why it's so important for you to read those 100 cases out of Search and Seizure Law Report. And there's probably 1,000 cases in there. You just need to read about 10% of them. And then you'll learn from the Search and Seizure Law Report all of the various and sundry issues that have occurred, various times and circumstances and places and events that other people have lived through and tried to suppress the evidence, and the lower courts refused, and then they took it to the Supreme Court and succeeded in getting it suppressed. When you've got that between your ears and your gray matter, then it's just there. You know it. And when you're at the scene of the crime or you're in the jail or you're writing a motion or a brief or something, it'll just flow right out of your brain. You'll say, oh, yeah, I remember that case. And, yeah, I remember that one. Oh, gosh, yeah, and I remember Schmerber. And, oh, yeah, and I remember Donald over here and Powell and Powers and Terry. And, gosh, that's what you need to do on the suppression. All right, now, from suppression, then, let's go on to your right sua sponte. There's another old common law move that I learned from a lawyer friend of mine. On right sua sponte, it's just a one-page brief in here. Let me see if I can just find it quickly. It's number 16 in this Lesson 9 file folder, so take a look up here, and while I make a comment on this right sua sponte, I want you to notice that the number 16 is on there for a reason. Now, here's what I did. I write the number 1, 2, 3, 4, 5, and etc. in my nomenclature in my file folder. Then I write the number on my brief and on the judge's brief, but I don't write it on the prosecutor's brief. It's not my responsibility to collate and number and do the paperwork for the prosecutor. So that way when I get in the courtroom, I'll leave him over here fumbling around trying to find paper, and the judge and I are on number 16. That's just a little harassing tactic that I learned. One time I was delivering paper up here to the local prosecutor's office, and if you'll notice it says received, there's always a stamp on there, and what I like to do is to take the 3 copies first of all into the prosecutor, have him stamp all 3, give him one, then go over to the court clerk and have her stamp 2, so that way I have the prosecutor's stamp on the judge's copy so that he can see that I served a copy to the prosecutor, and they refused to do that. And this particular prosecutor, he was just real vexatious and nasty to me. And he said, we're not going to stamp these copies for you. There's no rule that says we have to do that. And he just really got truculent with me one thing and another. And I said, well, gosh, that's real sorry to hear that, and blah, blah, blah. I like to be real pleasant to everybody, and I'm terribly sorry that you're offended in one way or another. And so I went right over and I filed about 10 or 15 motions. I think there was 200 pages, something on that order. And I went through and I shuffled all of the pages. Say, it's not my responsibility to collate that paper. And I figure that anybody that wants to play sandbox with me is playing sandbox with the wrong guy, because I'm one of the champion sandbox players. I can play kid like no one can play kid. And so I went up there and I just dropped about this much paper, just like this. Plunk. You've been served, sweetheart. And I took 2 witnesses with me, and then I filed an affidavit of proof of service. See? In other words, it's one more sheet of paper. And on that, I listed all the motions and briefs and affidavits that I'd served in that pile of paper. Went back in about 3 or 4 days later, and boy, was that prosecutor mad. I says, gosh, how you doing, Charlie? And he said, he was just really mad. Well, I'm still sorting through this paper you brought in here. Why are you doing that? You're not going to read it anyway. You haven't read any in the years that I've been bringing it in. You're just as dumb as you've always been. You haven't learned a thing. And I don't see any reason for you to sort it out and collate it. Well, why are you doing this? It cost me an extra penny a page to collate it, and I figured there's no need for me to collate the paper, seeing how you're not going to stamp it in for me and give me proof of service. So since I've got to go to the trouble of filing an affidavit of proof of service, I just figured I might as well just leave it for you to collate. Now, you want to play kid with me? I'll show you how to play kid. Now, that particular prosecutor has never liked me since, and that's the way I deliver my paper to that particular prosecutor. The other prosecutors, when they act like adults with me, what I do is I stamp it in their office so that I have a record that it was stamped in and delivered, and that's my proof of service. Don't ever kid yourself for a minute that when you're delivering paper that they won't pull a lie on you and say, well, gee, Judge, they didn't serve us with this process, because I've had them do that to me. They don't do that to me anymore. I always take a person with me when I go serve the paper. Now, let me leave you another, just before I get into this right sua sponte, it just triggered my mind. I want to give you one more little trick here. You know that proof of service, or that notice of the hearing, rather, has to be served on the prosecutor. Well, in the early days, I used to just walk in there and serve the notice of hearing on the prosecutor, and do it sometimes with 1 or 2 pages or papers and put it right on top. Now what I do is I stick it in the middle, because, you know, a lot of these prosecutors, they don't want to read my paper, and so they'll just take the whole thing and file it in their case, and then, because they didn't read the paper, they don't show up at the hearing, and then I move for dismissal. I learned that from a judge, by the way. Yeah, that's right, a judge taught me how to do that. And after all, when you're served paper, you better read all that paper that's been served on you, because you may be noticed up to a hearing. Always look through the paper for the notice of hearing, because that's a trick that can be used by you and by them. I've won 3 or 4 cases by simply showing up at a motion hearing and the prosecutor is not there. And I'll tell you, the key time to try to get a motion hearing is on Friday afternoon at 4 o'clock. Because, boy, prosecutors like to be out of their office by 2:30 or 3 and up in the mountains for an early weekend. So try to schedule it for 4 o'clock on Friday if it's possible. And when you notice it up, it's like this. You got a case going, you bring in 5 motions and briefs. You do that on Monday. Then about Wednesday or Thursday, you bring in 5 more. And then on about a Friday, you see, late in the afternoon, when there's only 1 girl left in the office, you bring in 6, 7 motions, and you drop those on the desk with the notice of hearing in the middle. She'll file those away, and then you've noticed up a hearing for the next week or the week after, and 2 weeks later, you'll be amazed at how many times those prosecutors will fail to show up. Move for dismissal immediately. All right, now looking over here at notice of demand for right sua sponte, it's number 16. I want to just give you a sample lesson here of what this is. It says, comes now the accused, a free and natural person appearing specially and not generally herein, to move the court to honor the demand to protect and preserve all rights of the accused as follows. Notice that when you're making a motion for rights, you do not confer jurisdiction on the court. It's when you make a motion to the court for something that the court can deliver to you In that case, then, it's a motion that confers in personam jurisdiction. Just take a look at jurisdiction and motions here in Bovier's, and you'll find out how that's done. Oftentimes when you see it in print here in Bovier's or some law dictionary, it'll trigger your mind and it'll stick in there a little better than just having me tell you. So you'll notice some of these say notice of demand for, and some say motion. When a motion is put in, make sure that you're not conferring jurisdiction to the court by asking him for more time or for asking him for a glass of water. Because if he's got the power to grant it, he's got the power, then he has to have the power of jurisdiction over you to do that. Going on then, that this court notify the accused of any violation of rights under the common law, whether enumerated in the Constitution of the United States or the state of Idaho, federal, state, or county statutes, or by any rules of procedure sua sponte. And the word sua sponte simply means right now. I want my rights right now. That such notification take place prior to the accused losing such rights or the violation thereof in order to protect the accused said rights from any source. The accused reminds the court that this free and natural person has never pleaded before the court, has not granted jurisdiction over this person, and continually challenges the jurisdiction of the court over the subject matter and its capability to effect a remedy in this case. In addition, if the court fails to timely notify this person of rights sua sponte or those declared or demanded by this person, the court on its own volition denies itself jurisdiction. Notice at the bottom of every one of these it says oral argument demanded. Okay. In order to get these motions and briefs into the record in the court transcript, you must demand oral argument and then go in, motion up a hearing and go in and argue them. Now, they become a part of your permanent record by simply filing them. But what happens is that you waive a very valuable opportunity to educate judges and prosecutors as to the common law that we're trying to reestablish here in our country. Now, remember, they've applied this Roman civil law upon us through contract. And they've done it in the last 80, 90 years by convincing us that debt is the way to get rich and that anybody who's not in debt, there's something wrong with him. But when you're in debt, remember that the debtor is servant to the lender, and so we're all servants to these major corporations. And these major corporations like Transamerica Company and Bank America and Citibank and all these major lending institutions are corporations controlled by government. So we've all become serfs and slaves to our government through these debt instruments, mortgages and financial agreements and arrangements, with the finance companies. We've been through that in lessons before, but now here you are, a slave, and you want to get your freedom back. You want to assert your common law rights, and these judges don't know anything about them. A lot of them don't. One of the rights is an example here that the judge then will have to tell you about is your right to challenge the state's prima facie case. And what you've done here is set a big bear trap. Because, and these prosecutors, they just really loathe this particular motion. I think most of them understand what you're doing to them here, because here you're in the court and you're just Joe Blow citizen. The Supreme Court has said that you've got to inform this person. It has to be a knowing waiver of your rights. Knowing and intelligent waiver of your rights is absolutely necessary and imperative. That's why they prosecute you by information and ask you if you waive your rights to this or that or something else. They know pretty much what the law requires, or somebody has over the years, and they've set up a very elaborate, elaborate I think is the word, labyrinth of spider web for you to negotiate your way through and to get stuck and trapped in so that they can always catch you and then put you in prison with your own permission. And always do it with your contract or your permission because you signed some document somewhere and granted jurisdiction. Now, what you're doing here then is putting a big bear trap out here in the middle of the trail, and you're saying, now, Judge, if during this process you violate any of my rights, you've been put on notice. You've said, I demand all my rights, and he tells you, no, you can't have lay counsel. You've demanded all your rights sua sponte, and the state rests its case, and he doesn't tell you that you now have a right to challenge the state's prima facie case. You get to the end of the trial, then the jury finds you guilty. The judge fails to inform you that you have a right to file a motion now to challenge that jury verdict and move for a verdict notwithstanding the jury, or a declaration, how do they word that, a declaratory judgment, I think, notwithstanding the jury verdict. And he fails to inform you of that. He fails to inform you of procedural rights. And when he does that, then he's committed reversible error. And then on appeal, you bring those up out of the transcript. You look at the transcript and you say, oh, I forgot to do this and this and this and this and this. And you know, many lower court judges aren't even capable, they don't have the capacity to even conduct a trial. You'd be amazed at some of the trials that when you get a little knowledge, you know, between your ears and you get into that courtroom and you watch a trial procedure at the constant and continual errors that judges will make. Especially in the traffic courts. I'm telling you, those guys out there in those traffic courts are nothing but clerks. In fact, I've seen clerks that had more, you know, there are legal secretaries that would make better judges than a lot of those political hacks that are appointed to traffic courts.